Much for staying on this channel. This is Law School Made Easy at Law School Made Easy 256. Keep subscribing, liking and sharing our videos. It does us good or better when you share and like our videos. Today we are going to enter into criminal law. Like we promised, we are going to be handling topic per topic per topic. But of course, our next topic on criminal law shall be principle of legality. But today, let's enter into why do we study criminal law? Simply because students tend to confuse this question. When this question comes, they only write the reasons why we study criminal law and they never relate it to the cases. This is criminal law. So when you are handling, or this is law, you must have a background of cases. You must go deep into these cases and read them and understand them, and then you put a case on almost every point. So let's enter into why do we study criminal law. Number one, criminal law is a branch of law that is designed to protect society from the increasing crimes. That the government wants to protect our society from crimes. That is why government punishes those who do the crimes in society. They want our society to be at sanity. That is why in criminal law we have Uganda versus the accused. Uganda versus the accused. The state versus the accused. Why? It is the government has taken over the side of the victim, and now it is the government against that person. Of course, when we begin to look at other principles, the burden of proof, principle of legality, and others, you know why the government takes over. So that is what we mean by criminal law. So we shall go straight into why do we study criminal law. Number one, we study criminal law because of retribution purposes, retributive purposes, that we want to satisfy the victim and the victim's family. That government will come to punish somebody who has done a crime simply because they want to satisfy the soul of the victim who is affected, and the person and the family and other people who are affected by this crime that the accused has done. So that is why we study criminal law, and that is what we call retribution purpose. So when you discuss retribution purposes, now you give a case. We shall use, there are cases which are very good that cover all the 5 reasons why we study criminal law. Let's use Uganda versus Mawa Charles, aka Mambo. Now, Mambo or Mawa Charles had sexual intercourse with a juvenile of about 14 years, a young girl of 14 years, and the girl got pregnant. When the girl got pregnant, she gave birth. So Mawa was brought to court for prosecution, and he pleaded that he first pleaded not guilty, and later he pleaded guilty. So he was punished. Justice Stephen Mubiru, when still in Germany, where this case occurred, had suggested 20 years of Mambo in prison. But on considering very many factors, that Mambo had become a young parent, that the other girl who was young, she has now given birth, they need to take care of this child, and Mambo is supposed to be the breadwinner, and Mambo having considered, so he was punished. Now, the punishment given to him reduced from 20 years to about 7 years. It was for retribution. They wanted to satisfy the people who were offended, to satisfy the parents that this girl had dropped out of school. So the punishment was given for retribution purposes. So when you explain that case, you must give the reasons why was this case punishment given for retribution purposes. So that is the reason why we study criminal law. Let's go to another one for deterrence purposes. Deterrence purposes. Now, for deterrence purposes, it means that we don't want such an act to repeat. That it is a deterrence. We are deterring other people from performing such an act. We can take a case of Dr. Matthew Chirabo, Uganda versus Dr. Matthew Chirabo, the doctor who killed the girlfriend. Now, the punishment given to doctor, because he was convicted last year, the punishment, last year, that is 2023, the punishment given to Matthew Chirabo is for deterrence purposes, to make sure that other people do not go into doing such, to prevent others from doing such a crime. So that is why Matthew Chirabo was punished. We can go to another one, and this could now be for reformative purposes, that we want to cause reformation, the reform, that the person who has committed this crime, to reform. You are punished such that you reform. We can take a case of Mawa, Charles, Uganda versus Mawa Charles, where Mawa was given 20 years in prison, but reduced to 7 years. But with a lot of caution, Justice Mubiru, in his judgment, when you read it, he cautioned this person. So we are causing reformation. We are picking out the part of reformation from that case. Where was reformation? So criminal law is given such that somebody reforms. It can be the accused or the other people who would wish to do the same, to cause reformation in society. Then we can take another one, maybe for educative purposes. Educative purposes. Here we mean that criminal law, that we apply criminal law simply because it is for education purposes. Even here right now I am teaching you about criminal law, about Mawa, about Kamau, Uganda versus Kamau, about Uganda versus Dr. Matthew Chirabo. So that educative purposes, to cause educative purposes, to ensure that people learn from the mistakes which have been done. That is why we punish. We want people in society to learn, to know that this is bad, this crime is bad, and that crime is bad. That is why we punish. So you can go ahead and use a case of Dr. Matthew Chirabo versus Uganda versus Dr. Matthew Chirabo, or Uganda versus Kamau. You can even bring back the case of Uganda versus Mawa Charles aka Mambo. These three cases I'm giving you, they cut across. Even if you choose to use just one case, read one case and then you can apply it elsewhere. But you will be an average student. A good student will get all the 3 or 5 cases, and on every point you put a case. Finally, why do we apply criminal law, or why do we study criminal law? Is for preventive purposes, to prevent further crimes. That we want to prevent further crimes. That is why Mawa Charles was imprisoned for 7 years. That anybody else who wishes to know that when you do a crime, you're going to be punished such that this thing does not repeat. You don't repeat it, or society, other people's society, they do not repeat it. So that is why we study criminal law. Number one, we have said for retribution purposes, to satisfy the souls of the people who are the victims, for educative purposes, for preventive purposes, deterrence purposes and reformation purposes. So that is why we study criminal law. But the most important on this topic is find out the cases. For every point, you attach a case and you show that in this case, this person was punished because of retribution. This person was punished because of deterrence purposes, because of education purposes, because of reformation purposes, or preventive purposes. So that is why we study criminal law. And in our subsequent video, we shall definitely look at the principle of legality, and thereafter in criminal law videos we shall also look at the burden of proof, and then we proceed. So we thank you so much for staying on our channel. We ask you to always subscribe, share and like our videos. Thank you so much. That has been why we study criminal law. Thank you.